Of the Senate Judiciary Committee will come to order. Today we have 5 judicial nominees to consider. Rupali Desai, nominated to the Ninth Circuit. Judge Doris Pryor, nominated to the Seventh Circuit. 3 nominees to the District of Puerto Rico. Maria Antonjorgi, please correct me when the time comes if I mispronounce your name. Judge Gina Mendez Miro and Judge Camille Velez. An impressive list of nominees. Welcome to the nominees and their families. I'll introduce our Puerto Rico District Court nominees shortly, but first I'd like to make a brief comment. On today's first panel is Judge Doris Pryor, nominated to an Indiana seat on the Seventh Circuit Court of Appeals. If confirmed, she'll be the first judge of color from Indiana to ever serve on that court. And there is another important first here. Judge Pryor is the first circuit nominee this Congress who's received blue slips from 2 Republican senators. I know the nominees know what that means, but for those who might not, it is a slip given by the senators from the state of the nominee to approve their nomination. When I spoke to Congressman Andre Carson at the beginning of this process, I encouraged him to reach across the aisle and to work with his Senate delegation to see if they could find common bipartisan ground. So I want to personally thank Senator Young and Senator Braun for working in good faith with Congressman Carson and the White House on this vacancy. Judge Pryor is an outstanding nominee who is proof that the process can work. When Judge Steve Locher became the first district court nominee this Congress to receive 2 blue slips from 2 Republican senators, Senators Grassley and his colleague Senator Ernst, I said I was hopeful that charted a path for others to follow. It certainly seems they did. I now turn to Ranking Member Grassley for opening remarks.
Well, good morning and congratulations to all of you who have been nominated. Says 2 circuit court nominees and 3 district court nominees before the committee today. Judge Pryor has been nominated to a seat on the 7th Circuit. She served almost her entire career as a federal prosecutor in Indiana, and she clerked for 2 federal judges. Ms. Daisy has been nominated to the 9th Circuit for the seat that belongs to Arizona. After clerking for Judge Mary Schroeder, she's worked in private practice. She focused on First Amendment cases and political and election laws. We also have 3 district court nominees for the District of Puerto Rico. All 3 courts frequently handle important constitutional questions, so I'm going to be very much interested in how these nominees handle their approach to the law. It's important that we have judiciary that interprets the law as opposed to writing it, not just to reach the results that judges like in an individual case. Welcome to all of you and congratulations on your nomination.
Thanks, Senator Grassley. We're now going to hear introductions for our nominees. We have 2 colleagues here today who will each make a statement of introduction, and then, of course, will be excused to their busy schedule. The first is Senator Kirsten Sinema to introduce Ms. Desai. Senator Sinema, please proceed.
Well, thank you, Chair Durbin, Ranking Member Grassley, and all the members of the Judiciary Committee for the opportunity to introduce the nominee for the Ninth Circuit Court of Appeals, Rupali H. Desai. I've had the pleasure of knowing Ms. Desai both personally and professionally for many years, and it is my honor to support her nomination. Rupali is the daughter of South Asian immigrants. She was raised in Glendale, Arizona, and she is a triple alumna of the University of Arizona. Please do not hold that against her. I'm an alumni of the Arizona State University. Rupali clerked for the Honorable Mary Schroeder, who was the Chief Judge of the Ninth Circuit, the court to which Rupali has been nominated. She is one of the most experienced and respected lawyers and litigators in the state of Arizona. She's a partner at Coppersmith Brockelman in Phoenix, where she has a broad legal practice focusing on complex civil litigation, constitutional law, political law, and civil appeals. She represents clients at all stages of litigation in state and federal court, in front of administrative agencies, and in arbitration proceedings. Her clients range from large and small businesses, nonprofits, and even the professional firefighters of Arizona. Rupali is a tireless advocate for a better Arizona, and her commitment to the community extends beyond her legal cases. She was named as one of 12 national honorees for USA Today's 2022 Women of the Year. She serves on several community boards. She's a professor of practice for the University of Arizona James E. Rogers College of Law, and she volunteers at the Family School in Phoenix, where she helps ensure families experiencing food insecurity have access to healthy, nutritious food. Her nomination to the Ninth Circuit is supported by a broad coalition of elected officials from across the political spectrum, including my fellow senator from Arizona, respected legal experts, law enforcement organizations, and lawyers who served as opposing counsel in cases Rupali has litigated. In their letter to this committee, the Arizona Police Association President Justin Harris and Executive Director Joe Klur write, "Our organization has worked with, against, and alongside Rupali for many years. We know Rupali to be a talented lawyer and a tireless worker, but most importantly, we know Rupali to be committed to the rule of law." And Daniel J. Edelman, the Executive Director of the Arizona Center for Law and the Public Interest, writes, "Ms. Desai brings a superior intellect and a seemingly boundless work ethic to everything she does. She has an enormous respect for the Constitution and the power of the law to make people's lives better. She is selfless, dedicating countless pro bono hours to help those who otherwise would have no one to fight for them. For these reasons, and many, many more, I am proud to support her nomination. It is my honor and my privilege to introduce Ms. Rupali H. Desai, and I urge my colleagues on both sides of the aisle to support her nomination to the Ninth Circuit Court of Appeals, where I know she will serve our country with distinction. Thank you, Mr. Chairman."
Thank you, Senator Sinema. And now we recognize, and of course you're excused, I know your schedule's busy, as most senators are. Senator Young?
Thank you, Chairman Durbin, Ranking Member Grassley, members of the committee. It's a privilege to be with you today. I am honored to appear before you to introduce Judge Doris Pryor, President Biden's nominee to serve on the United States Court of Appeals for the Seventh Circuit. Judge Pryor, welcome to you and your family. I'm appreciative of the President's willingness to consult with me and Senator Braun when this position became available in an effort to appoint a judge who has earned respect and support from all sides of the political aisle. I'm confident that this committee will be just as impressed with Judge Pryor as I have been. Judge Pryor is not a Hoosier by birth. She found her way to the Hoosier state. She was born and raised in the state of Arkansas. She came to Indiana University for law school. Following law school, she returned to Arkansas to clerk for Judge Leon Holmes and Judge Levinsky Smith. She also served as a public defender in Arkansas before returning to Indiana to serve as an assistant U.S. attorney in the Southern District of Indiana. Since March 1st, 2018, Judge Pryor has served as magistrate judge for the Southern District of Indiana. As you can tell, she has experience on all sides of the courtroom. She understands the difference between the role of an advocate and the role of a judge. And she has experience both on the criminal side and on the civil side of the docket. Since her name came up, I've heard an outpouring of support from across the Indiana legal community, including a diverse array of support letters that have been provided to this committee. I'd also be remiss if I failed to mention the historic nature of this appointment. If confirmed, Judge Pryor will be the first African American from Indiana ever to serve on the Seventh Circuit. For all of these reasons, I support Judge Pryor's nomination, and I look forward to voting to confirm her on the Senate floor. Thank you.
Thank you very much, Senator. We appreciate your being here too. And like Senator Sinema, I know you have to go to other events, and we'll continue with the hearing. And of course, remember your remarks. I now will introduce the Puerto Rican District Court nominees, and then we'll have the first panel, which would be Ms. Desai and Judge Pryor to come before us. Let me introduce the Puerto Rican District nominees who will be on the second panel. I'm pleased to introduce Maria Antongiorgi, one of the three nominees to the District of Puerto Rico. Ms. Antongiorgi earned her BA from Seton Hall University, her JD from the Inter-American University School of Law, and her LLM from highly regarded Georgetown University Law Center. That's where I went to school. After graduating from Georgetown, Ms. Antongiorgi joined the law firm of McConnell Valdez in its San Juan office, Over the course of nearly 2 decades with the firm, she had a wide range of litigation practice, complex civil matters, and criminal defense work as well. In total, she participated in an amazing 42 trials. There aren't many who can say that, and served as chief or co-chief counsel in 36 of the 42. In 2018, appointed Chief Deputy Clerk of the U.S. District Court for the District of Puerto Rico, 2019 promoted to Clerk of the Court. As Clerk of the Court, she helped the court navigate the COVID-19 pandemic and kept the court functioning. I look forward to hearing about her current work and her considerable experience. The second nominee to the District of Puerto Rico is Judge Gina Mendez Miro. She has a BA from the University of Puerto Rico, MA from Princeton, JD from University of Puerto Rico. After working in private practice for several years, she spent the rest of her career in public service. She's worked on all 3 branches of the Puerto Rican government: the Department of Justice, the Judicial Branch Court Administration, and the Puerto Rican Senate. In 2016, the Puerto Rican governor appointed Judge Mendez Miro to the Puerto Rican Court of Appeals, a position which she was unanimously confirmed to by the Puerto Rican Senate. As a judge, she's presided over a range of civil and criminal appeals. Welcome, Judge Mendez Miro, and your family and friends. I'm also pleased to introduce Judge Camille Velez this morning. Judge Velez currently serves the District of Puerto Rico as a magistrate, first appointed in this role in 2004, only the second woman to serve as magistrate judge for Puerto Rico. And over the past 18 years, she's handled a variety of criminal and civil matters, including presiding over 26 trials that have gone to verdict or judgment. Prior to her service on the bench, Judge Velez served the district as Puerto Rico as an assistant U.S. attorney, spent 2 years in the criminal appellate division, drafted over 80 appellate briefs, argued 10 times before the First Circuit Court of Appeals, spent 4 years in the civil division, handling approximately 65 cases and bench trials. Born and raised in Puerto Rico, she earned her JD from the University of Puerto Rico Law School after receiving her BA from Washington University in St. Louis. After graduating, she clerked for Judge Francisco Rebollo Lopez on the Supreme Court of the Commonwealth of Puerto Rico. I believe Judge Velez extensive experience on and off the bench will serve her well as a federal district court judge. Thanks to all the nominees and for their patience this morning. We'll now turn to the first panel and ask the 2 circuit court nominees to come up to the table and to stand and be sworn. Do you affirm the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that both nominees have answered in the affirmative as we hoped they would, and we'll start with Ms. Desai.
Good morning. I would like to start by thanking you, Chair Durbin, Ranking Member Grassley, and the entire committee for providing me with the opportunity to appear before you today. I would also like to thank Senator Sinema for her warm and gracious introduction and for her support, and also thank you to Senator Kelly for supporting my nomination. I am grateful to President Biden for this incredible honor and for the opportunity to serve the people of our great nation. This is the nation that my parents singularly aimed to immigrate to more than 40 years ago, to live a better life and to give a better life to their children. My mother completed her last round of chemotherapy just in time to fly here from Arizona to be here with me today. She has the strongest spirit and work ethic of any person I know, and I'm inspired by her. My father couldn't make it in person, but he is here watching remotely, and I'm fortunate to have them both with me. I'm also fortunate to have here with me my sister and my brother, who have been my biggest cheerleaders and sounding board for as long as I can remember. And perhaps you can see behind me 3 little girls. Those are my daughters, ages 10, 7, and 5. Hopefully they are sitting still as statues, which may earn them an ice cream later this afternoon. They are smart, strong, inquisitive, and kind. And they, along with my husband, Jay, of 20 years, are the backbone and my light. My sister-in-law, Katie, and my niece, Anya, also flew here from Phoenix to be with me. My other nieces and nephews, parents-in-law, and family from all around the country and the world are also watching remotely. And finally, I am joined by my mentor and dear friend, Keith, and my close friends, Anne, Michelle, Andy, and Kristen. I want to thank them, my law firm family, and countless other friends and mentors who are watching remotely for their encouragement and support. Before I conclude, I want to share why this nomination has special meaning to me. This particular seat on the Ninth Circuit, for which I have been nominated, was created by Congressional Act in 1978. Judge Mary Schroeder was nominated to fill the seat, and she became the first female judge to serve on the Ninth Circuit. 25 years later, I had the distinct honor of clerking for Judge Schroeder when she was the chief judge of the circuit. Judge Andy Hurwitz was the second judge to serve in the seat, and now I've been nominated to fill the vacancy. I am grateful to Judge Schroeder and to Judge Hurwitz for their service and mentorship, and I'm deeply honored to be considered for this position. I look forward to answering the committee's questions. Thank you.
Thank you, Ms. Desai. Judge Pryor.
Good morning. Let me start by thanking you, Chairman Durbin, Ranking Member Grassley, for convening this hearing today. And to all the members of the committee, I am so grateful. I recognize that it is a privilege to sit in this seat. And for you taking your time to consider my nomination this morning, I am so grateful. I must also acknowledge my overwhelming gratitude that I have for my adopted Indiana home state Senator Todd Young, for those warm introductions, as well as to Senator Braun for his unwavering support. As my Arkansas family were reminded just this morning, Hoosier hospitality is alive and well. I am grateful to President Biden for this nomination and for the honor of being considered. I would like to, if given the opportunity, to introduce the real source of my strength. They're seated right behind me, my family. I want to express my overwhelming gratitude for their continued love and support. My grandmother, seated to my left, Doris Brown, was kind enough to share her first name with me. I also have to thank my loving parents, James and Linda Clark, who taught me the essence of hope and traveled from Arkansas to be with me today. To my beautiful mother-in-law, who has traveled from the Midwest to support me and has really been a source of strength at every stage of my professional career. And to my best friend, who also happens to be my husband, Johnny Pryor, thank you. I am so grateful for you. And to my son, who has continuously taught his parents the power of both fearlessness and faith, thank you. I would be remiss to not also acknowledge the host of family and friends and colleagues who are not as fortunate to be in the room with me this morning, but are watching remotely from Indiana, Arkansas, Texas, Louisiana, Mississippi, California, Virginia, Maryland, Ohio, Georgia, and throughout the country in support of my nomination. Thank you. Chief among them, I have to thank my brother who taught me early on, Doris, all superheroes don't wear capes. And to my court family and all the members of my chamber staff, thank you for your support. At this time, I welcome the committee's questions.
Thank you, Judge Pryor. We'll start with Ms. Desai. Well, there's one case of yours that everybody is taking a look at, I'm sure. Mi Familia Vota versus Hobbs. Can you tell us how you happened to be an attorney on that case and what was decided by the court?
Thank you, Chair Durbin. I would be happy to. And that case was an interesting case for at least two reasons. The first was that I was not involved in that case at the district court, at the trial level. But I'll give you a little bit of background. The case was brought a few days before the deadline for voter registration in the state of Arizona by the group Mi Familia Vota. They requested that the court enter an order extending the time to register to vote, and the district court judge in that case granted that order extending the time for voter registration until just a few days before the general election in 2020. After that order came down, my client, the Secretary of State's office, asked me to take an appeal of that order to the Ninth Circuit. That decision was in large part made because of the impacts to the administration of elections in Arizona and the difficulty that would be faced by recorders all over the state of Arizona if they were having to accept voter registrations up until days before the election. I filed documents to appeal that order with the Ninth Circuit, which is where the second interesting part of this case comes into play. I decided on behalf of my client that it made sense to reach out to all the parties in that case, including not just the plaintiffs, but both presidential campaigns had intervened in the matter, to ask if there was any compromise position that the parties would agree to that we could propose to the Ninth Circuit. On appeal, we argued the merits of the case, but also were able to present to the court a compromise. The compromise was to, in fact, reverse the order extending the voter registration deadline because of the other conflicting deadlines and difficulty to the administration of elections, but to at least provide some recognition of people who might have registered to vote from all political sides in reliance of the district court order. And that is what ultimately the Ninth Circuit panel in the case did hold.
Do you have any questions in your mind as to the validity, accuracy, or honesty of the vote that was reported by the state of Arizona to the Electoral College?
Thank you, Chair Durbin. What I can speak to is the litigation that I was involved in the state of Arizona. There were a number of cases that were brought challenging the official canvass. I represented the Secretary of State's office in those matters, and the courts held in each and every one of those cases, when they adjudicated all of the claims on the merits, that the official canvass was in fact valid and should be upheld.
Do you have any evidence or belief to the contrary?
Senator, what I know is the evidence and information that was presented in those cases. I believe the courts looked at everything carefully and thoroughly, and ultimately the decisions of those courts are the ones that I look to and honor as the rule of law.
Thank you. Judge Pryor, you were involved in a case as a prosecutor with a defendant, Akram Mosley, I may have mispronounced the name, a U.S. citizen who attempted to provide support and resources to the Islamic State of Iraq and the Levant. Would you comment on that case?
That case was a material support case. The defendant was attempting to travel abroad to join Al-Qaeda, and the Department of Justice, made the decision to charge this individual with material support of a terrorist organization.
And what was the outcome of the case?
The outcome of the case, that young individual was sentenced by Judge Barker. During that investigation, however, I was elevated to the bench, and so there were other members within the Department of Justice who completed that prosecution.
Thank you, Judge. Senator Grassley?
Yes, I'm going to start out with Ms. Dizze and ask you about a election case you participated in, Bronovich versus DNC. You were part of a amicus brief. Your brief argued that an Arizona law 2023 banning ballot harvesting was racially discriminated and violated the Voting Rights Act. Why, in your view, can't states ban ballot harvesting?
Thank you, Ranking Member Grassley, for that question. I filed an amicus brief on behalf of two clients in the Supreme Court in that case that you mentioned. And the arguments made by my clients in support of the DNC was that the two election laws in Arizona violated Section 2 of the VRA based on a number of facts that were set forth in the Ninth Circuit opinion, finding that those laws did in fact violate Section 2 of the VRA. The Supreme Court disagreed with that position, but did in fact employ a test that looked at various facts to determine whether laws are passed either with discriminatory intent or have discriminatory results. And that Supreme Court ruling in Brnovich v. DNC set forth various guideposts that I would follow if I am so lucky to be confirmed to the court.
Okay, thank you. I want to ask about another case dealing with religious freedom. In Bryce, you filed a amicus brief. Your brief argued that Phoenix was required to force owners of an art studio to create custom wedding invitation celebrating same-sex weddings in violation of owners' sincerely held religious beliefs. You compared the situation to a hotel owner who banned a Jewish group from using a hotel pool, and to a shooting range that described itself as Muslim-free zone. In your view, is a decision to decline to print same-sex wedding invitations religious discrimination?
Thank you, Ranking Member Grassley. In that case, I represented a group of religious organizations that sought to file an amicus brief to urge the position that a facially neutral and generally applicable anti-discrimination ordinance in the city of Phoenix did not violate the Free Exercise Clause, and that a broad exception to that rule could raise concerns about the Establishment Clause. The Supreme Court of Arizona disagreed with that position, and since that case, there have been a number of cases decided by the U.S. Supreme Court on religious liberties. And if I'm so fortunate to be confirmed, I will uphold the rule of law and the precedent of the United States Supreme Court on the religious liberty and free exercise clause rulings.
Let me go to Judge Pryor. On May the 24th, 2014, you delivered a presentation to a group of students to improve their financial literacy. You identified that the students would need to provide two forms of identification, and then you had several things they could pick from to make that but you noted that, quote, a major topic was to emphasize proper identification. And of course, I agree with you on that point for opening a bank account. But my question to you is, should voters be required to show identification when they go to polls? If not, why not?
Thank you, Ranking Member Grassley. Let me start with that presentation that was made in May of 2014. We were expressing to the students the importance of financial literacy and that what you would need to open a bank account in the context of voting rights and the ID that will be required to be able to vote. As a federal judge, I must be careful not to speak as to my personal opinion. I will agree, Ranking Member Grassley, that I will continue, as I've done over my years on the bench, to be sure to follow binding precedent of the Supreme Court as well as the Seventh Circuit regarding laws applied as to the need for an ID for voter.
Okay, I'll have some additional questions for answer in writing. Thank you all both very much.
Thanks, Senator Grassley. Senator Whitehouse.
Thank you, Chairman. It's good to have you both with us. Let me ask you first, based on your experience, how important is the civil jury as an American institution? And I will frame that so that this is not a surprise question by pointing out that the United States Supreme Court seems to have been on a campaign for some time to deprecate and diminish the role of the civil jury by circumscribing its ability to assess damages, by taking questions away from juries, and by allowing big corporations willy-nilly to take away individuals' Seventh Amendment rights in very one-sided contracts so that you give up your right to the civil jury by virtue of signing up for telephone service or to open a bank account. To me, that's a matter of grave concern. I go back to the early Blackstone injunction that civil juries are actually a form of check in our society on the wealthy and powerful. And nobody's more wealthy and powerful in our society than big corporations right now. So it comes to me as, unfortunately, a very small surprise that this particular court would be engaged in trying to protect big corporations from civil juries. But with that background, what has your experience been of the importance of civil juries? And would you be doing your best as a judge to support and sustain the institution of the civil jury? Ms. Pryor?
Thank you. I truly believe that juries remain the bedrock of our democratic process. They serve a vital function in the administration of justice, and through my work on the bench, we're continuing to ensure that our civil jurors have voice in this process of justice.
Ms. Desai?
Thank you, Senator. I echo Judge Pryor's comments. I will also note that jury service, I think, is critical for both participation and faith of the public in our judiciary. If so fortunate to be confirmed to the court, I will apply Supreme Court precedent in this area, as well as obviously applying any laws that the legislature, Congress passes on issues of the right to a civil jury.
Let me ask you a slightly different question, and that is 8 of 9 Supreme Court justices in the Citizens United decision offered the view that anonymous political spending, particularly anonymous unlimited political spending, would be corrupting or present the risk of corruption. Do you have any reason to doubt that aspect of the Citizens United decision?
Senator, are you directing that question?
Yes.
Yeah. Thank you. Again, it is not for me sitting here before this committee as a judicial nominee to question the precedent of the United States Supreme Court. I would be bound to apply that precedent if I am confirmed. I have, as an advocate, made arguments on both sides of that case, but as a judge, I recognize that my role is not to be an advocate, but to apply the rule of law objectively and fully.
Let me conclude by observing that I have a First Circuit nominee who received the unanimous endorsement of our state Supreme Court, in addition to a great number of other members of Rhode Island's legal community. And I note that you have been recognized by the Arizona Supreme Court by them appointing you to the court's Committee on Civil Justice Reform. Could you reflect for a moment on what that means about your standing with the Arizona Supreme Court and bar that they would make that appointment of you?
Thank you, Senator. I'm very proud of my relationships with judges and lawyers and community leaders from both sides of the aisle. I was appointed to the Committee on Civil Justice Reform by the Chief Justice of the Arizona Supreme Court to participate in what was a remarkable effort to evaluate and improve the courts and access to the courts by the people of Arizona, a very worthwhile effort that I was honored to be a part of.
Well, congratulations on that signal of confidence in your character and abilities. Thank you, Chairman.
Thank you. Senator Kennedy?
Thank you, Mr. Chairman. Congratulations to both of you. Ms. Desai, am I saying your name right?
Senator, it's Desai.
Desai. You introduced your children, and I missed that part of your testimony. Are they here?
They are, Senator. My 3 daughters, one of them looks like she's asleep. She's probably not converted from Arizona time yet. They're 10, 7, and 5.
Okay. Kids, you can do a lot better than ice cream, okay? If you would like me to negotiate for you, I'll be happy to. Ms. Desai, Senator Durbin talked to you about a case on which you were counsel. Was that the case where plaintiffs sought to extend the voter registration period?
Yes, Senator.
Okay. This was a period of time set in statute by the legislature, as I recall, in which people in Arizona could vote.
Correct.
Right. And the plaintiffs wanted to extend that period of time.
Correct.
And they sued the Secretary of State.
Yes, Senator. Again, I wasn't involved at the trial court level, but if I remember correctly, the Secretary of State was a defendant. She might have been the only defendant, although I remember that the county recorders were involved at some point in that litigation.
Okay. Who was the Secretary of State then?
The Secretary of State at that time and currently in Arizona is Katie Hobbs.
And what party is she in?
She is a Democrat.
Okay. In that case, did you make the decisions, or did the Secretary of State make the decisions?
Senator, whenever I represent a client, I endeavor to make decisions with my client, and after advising my client fully of the options, take direction from my clients.
Yeah, that's the way it worked when I practiced law too. The Secretary of State decided to settle the case and extend the time to register the vote. Is that the ultimate outcome of the case?
Senator, there was discussion about a settlement, but the settlement could not be, if I remember correctly, there was not enough time to enter into and finalize a settlement. So the ruling from the Ninth Circuit panel is the ruling that the parties ultimately implemented for purposes of determining the outcome of the voter registration deadline.
So the Secretary of State and the plaintiffs went to the Ninth Circuit and asked the Ninth Circuit to issue that ruling?
Senator, what happened in that case, to the best of my recollection, is that there was conversations with all of the parties, so the plaintiffs, the Secretary of State, as well as counsel for interveners, which were both presidential campaigns. I think also the
Yes, ma'am.
parties.
Excuse me for interrupting, but I'm going to run out of time, Counselor. My understanding is, and I think it's accurate, that the Secretary of State and the plaintiffs went to the Ninth Circuit and said, we have worked this out. We recommend that you rule this particular way. Isn't that what happened?
Senator, I think it was all of the parties.
Right, all of the parties.
Correct, including the interveners, which included the political parties and the campaigns for both presidential candidates.
So the Ninth Circuit ended up changing the state statute ultimately.
Senator, the order from the Ninth Circuit, I believe, was to reverse the district court's order extending the voter registration deadline, but allowing voters who had relied on that opinion or that order and registered to accept those voter registrations.
Right. Okay. All right. Well, I've got 13 seconds. Ms. Pryor, explain to me, Judge Pryor, excuse me, explain to me the legal basis for a universal injunction.
For a universal,
Universal injunction, the legal basis.
the legal standard for nationwide.
Not the standard, the legal basis. Where do the federal district judges get the power to issue a universal injunction that affects everybody in the United States?
I understand, Mr. Kennedy, that question as to whether or not judicial officers have extended and gone beyond their limited power under Article 3 is a highly debated question of both public debate and discussion.
Yes, ma'am, but when a federal district judge issues a universal injunction that applies not just in his or her district, judicial district, but the United States, and the parties say, Judge, what is your legal basis for doing this? Is there a statute? Is it in the Constitutional? What is the answer?
within our district and the Southern District of Indiana, the injunction, the preliminary injunction, has been limited to that of the parties and the litigants.
Maybe I'm not being clear. I'm sorry, Mr. Chairman. Just, if you could, just tell me the legal basis. Where does a federal judge get the authority to issue a a universal injunction?
The authority that judges in the DC Circuit or in other areas that have applied a nationwide injunction, the question that was raised before the court, or the legal standard they have used, is questioning whether or not the federal government, a policy or executive power, can be executed. In those circumstances, those judges have issued what have been deemed as nationwide injunctions.
I know they have, but what's the legal basis for it?
Again, that's my understanding of when those have been enforced.
Okay. Thanks, Judge.
Thank you.
Mr. Chairman, thank you very much. I just want to thank you both for being here. You can rest because I just want to talk to you a few minutes. I do not have questions, and you're going to get an extraordinary legal mind coming at you next in the Senator Mike Lee, my friend. I just want to tell you both how grateful I am that you're here, how grateful I am to the president for nominating you. I think we are privileged to have you before us. You're both competent jurists. You both have demonstrated yourself to be truly qualified. You have bipartisan bona fides, which is pretty exceptional. And in this divided nation that we have right now, which is too tribal, you seem to have people echoing from both sides of the aisle to your qualifications, competency, temperament, and more. I am thankful for that. I'm also just grateful because I still am just remarking at what's happening to our judiciary, thanks to this president and my chairman, the diversity that's coming through. I remember when Tim Scott pulled us together and had an event with the 9 of the 11 African-American senators that ever served. And he and I sometimes have great conversations about the privilege it is to be in this body. But I will tell you that our government, this representative government, has not done a good job truly being representative. And you all are adding to the beauty and the glory of the country I love so much I die for. Ms. Desai, you are this immigrant. You give a testimony to one of the great notes within the Symphony of America. Your story is improbable, perhaps everywhere but here in the United States. And I am so grateful you're sitting before me right now. This is not a normal day. You are a triumph sitting where you are there. And I'm so happy that your mother is here. God bless her. I know you're struggling with health issues, but God has given you one of the great blessings to see your daughter ascend, I hope, to the highest court in the land. And your daughters, as great as you are, I have a suspicion that they will rise to even higher heights of service and contribution. Judge Pryor, you are literally a woman from hope. I love that. And I tell you right now, I'm going to see my mom this weekend. I will tell her about you, and she will celebrate with me this awe that we have, that women like you are now coming onto the judiciary at a level that we have never before seen in America. This president has put more African-American women on the circuit court than every other president before him combined. And you both are more than your gender and your race. You both are people of dignity, competence, and patriotism, which I think is what bonds our country together and is deeper than race and gender. You are also making your ancestors so proud, and I just love your son, don't even know him, but I know how great it is to grow up the son of an extraordinary Black woman. And so I celebrate your family, and I thank you for being here. I know that this process isn't easy, but I want to say again, this process is not usual. This moment right here is very different than the many, many years of American history before it. And you're very much being at this table right now is a cause for celebration. And I rejoice in you both. I want you to know I will vote for you, and it will be an enthusiastic vote as I take mark that this is a great nation, that God loves this country, and as difficult and as divided we are, I believe in us. I believe there's nothing that's wrong with America that can't be made right by what's right with America. And I'm confident that in your service, you will make us a better nation. And God willing, through your through your practice, you will help us to put more indivisible back into this one nation under God. Thank you.
Thank you, Senator Booker. I think you've definitively removed yourself from the undecided column on these two nominees. Senator Lee.
He sounded like he was on the fence on that. I always enjoy Senator Booker's remarks. He is a dear friend, and his remarks always give me hope and confidence in America. Thanks to both of you for being here and for your willingness to serve and to be considered for these positions. I've got questions for both of you. Let's start with you, Ms. Desai. In December of 2018, you submitted an amicus brief before the Supreme Court of the state of Arizona, a state where I happen to have been born. The case was called Brush and Nib Studio versus City of Phoenix. The amicus brief that you submitted was on behalf of the national organization known as Americans United for the Separation of Church and State. In this brief, you argued that it would be a problem to extend an exemption on the grounds of religious freedom to a particular small business, an exemption to an otherwise applicable state law, and that they should have to comply with that state law, even if forcing them to comply with that state law would require the company to violate sincerely held religious beliefs. Specifically, you made the argument in your amicus brief, I've got a copy of it right here, that, quote, the Establishment Clause does not permit religious exemptions that, instead of protecting religious institutions' internal exercise of their beliefs, substantially burden third parties who do not share those beliefs. What Supreme Court precedent do you rely on, or what principle of law are you incorporating when you make this argument?
Thank you, Senator, for that question. In that case, I filed an amicus brief, and I believe was co-counsel with Americans United, and we represented a group of religious organizations and religious affiliated organizations that were in turn interested in ensuring the protection of their religious liberties. The arguments that we made on behalf of our clients in that amicus brief had to do with the balance of the Establishment Clause and the free exercise of religion. As I think you noted, the argument was that the facially neutral and generally applicable ordinance, if a broad exception was granted, could in turn raise concerns on the other side.
Right. I understand that. And your argument was that this was a problem, that it would be a problem under the Establishment Clause. And you said that it was a problem under the Establishment Clause because it might substantially burden third parties who don't share those beliefs. I'm asking you from what you derive that argument. It's a line of reasoning that I'm not entirely familiar with. Now, you cite the 1963 landmark decision in Sherbert v. Verner as support for it. Your pinpoint cite to page 409 of that opinion seems to be the source of authority that you rely on. I don't see that from Sherbert v. Verner. So enlighten me as to where I'm wrong in believing that Sherbert v. Verner does not support your proposition.
Senator, I cannot, as I sit here before you, recall the citation that you reference. What I can tell you generally from my recollection was that the argument made was that if an exception to the facially neutral and generally applicable anti-discrimination law in turn could burden third parties, that might raise questions or concerns under the Establishment Clause. But I will also note that There have been a number of cases that have been decided by the Supreme Court of the United States on the topic of religious liberty, such as Tandon v. Newsom. And if I'm so fortunate to be confirmed to the court, I would faithfully and fully apply the precedent of the United States Supreme Court and the Ninth Circuit.
Okay, I appreciate that. It does cause me some concern because the source of authority is one you can't identify, I believe, because it doesn't exist. I'd love to be proven wrong. If you can prove me wrong on that after the fact, I would love to read that. Judge Pryor, the time I've got left, I've got a couple of questions for you. You gave a speech a few years ago at your son's school on Constitution Day. Constitution Day is a great day. Doesn't get celebrated enough, so I'm glad your son's school was celebrating. During this speech, you said that the Constitution's words, quote, permit us to live out the true meaning of its doctrine and interpret it as a living document, close quote. Can you tell me what you mean when you say that we should interpret the Constitution as a living document?
I truly believe that the Constitution is a document in what's so unique or in its genius. It's its ability, and the forefathers saw its ability and its need, if necessary, to be changed. Through the amendment process, we see the 13th, 14th, and 15th Amendment. This document as well, what's important about it is that the framers saw the need to be able to have this Constitution be able to apply to circumstances that they might not have thought of searching a cell phone or a wiretap.
So is I understand that. Does that mean that the Constitution's meaning changes over time?
As a judicial officer, I am guided by both, as well as the binding precedent of the Supreme Court and the Seventh Circuit. And so when looking at constitutional issues, I am guided by those opinions in making that determination.
Okay. Well, when you say it's a living document, does that mean that the meaning itself changes, or does it mean that the meaning established and embraced, codified within the Constitution at the time it was written, can be applied to other circumstances not foreseen? You referred to, search and seizure principles, for example. Founding fathers couldn't have imagined, those who drafted the Fourth Amendment couldn't have imagined all the means by which searches were carried out, but the principle still applies. So which one is it? Does the meaning change, or the circumstances to which it's applied change?
Again, I would be directed by Supreme Court direction on that question when we're looking at, for example, and most recently in the Broome case, ensuring in that direction when looking at firearms regulations, ensuring that when we're reviewing those, that the text that we're reviewing is in line with the Second Amendment as well as its historical understanding.
Okay. I see I'm out of time. I'd love to follow up more on this in writing. Thanks.
Thank you.
Senator Klobuchar.
Thank you very much, Mr. Chairman. Thank you. Congratulations to both of you. First, want to start out, Ms. Desai. I was first paralyzed at the thought that you go and, Judge Pryor, that you go and you talk at your kid's Constitution Day and it shows up at a Senate Judiciary hearing. But I thought I assume that's your son sitting behind you right there?
It is.
So he's responsible for that line of questioning?
He is.
Okay, all right.
We'll talk about it afterwards.
Okay, well, I thought you handled it well. So I'll start with you, Ms. Desai. The committee received a letter of support for your nomination from a bipartisan group of appellate lawyers and litigators who have worked on both cases with you, against you. They said that we have no doubt that she will faithfully and fairly apply the law to the parties appearing before her. That's precisely what we should demand of judges and precisely what we think Rupali will do if confirmed. Can you tell us more, just sort of stepping up a little from some of the more detailed questions, how you would approach the matters before you as a circuit court judge, and what is it about your legal philosophy or your temperament that has gotten you this respect of Democrats and Republicans alike that have worked with you?
Thank you, Senator, for that question. I am very proud of my relationships with folks on both sides of the aisle and am very honored to have their support. I think first and foremost, I can attribute my ability to work and be successful with folks on both sides of the aisle because I am genuinely interested in learning about and understanding perspectives that are different than my own. And I think sort of that mutual respect with individuals who are my opposing counsel has served me well. Second of all, I think that my respect for the rule of law, even when our clients might be opposed to one another and vigorously fighting in court, we all, the understanding between the lawyers and the judges who make decisions that sometimes I don't agree with, but that is the rule of law, and my utmost respect for those decisions and the rule of law when I practice, I think it contributes to my ability to work with folks on both sides of the aisle. I hope to be able to forge those kinds of relationships with my colleagues on the Ninth Circuit if I am so fortunate to be confirmed.
You received many letters of support, including one from the Arizona Police Association, whose executive board voted unanimously to endorse your nomination. In that letter, they write, "We know Rapalli to be a talented lawyer and a tireless worker, but more importantly, we know Rapalli to be committed to the rule of law. We are confident you will serve our state and nation with honor and integrity." Could you talk about what part of your professional experience you believe have earned you the support of such a wide array of law enforcement professionals?
Thank you, Senator. Again, I would point to my respect for the rule of law. Our system of justice demands judges to apply the law objectively, fair-mindedly, and to honor the precedent of our courts. And if I'm so fortunate to be confirmed, I am committed to doing that, and I will make the transition from an advocate to a judge in order to accomplish that goal.
Thank you very much. And Judge Pryor, since 2018, you've served the federal judiciary in Indiana as a magistrate judge. I've actually appointed, I think, 2 now of our federal judges from the magistrate pool, including recently Kate Mendez, who's now serving as a federal judge. And that's a position you were appointed to by the sitting federal judges of the Southern District in Indiana. I would assume that this includes judges from presidents from both political parties. Is that right?
Yes, that is correct.
And how will your previous judicial experience inform your approach to appellate decision making? What have you learned from your time as a judge, and how will that guide you in taking on this new role?
As I sit here this morning, I've handled over 7,000 matters, written hundreds of opinions, and my approach to the law has been that of ensuring that when writing an order is that my decisions are guided by the facts on a case-by-case basis. It's important that judges follow the law and not be guided by any personal bias or any religious preference or political ideology. And so, as I've done over the past 4 years, I will continue to do and ensure that my decisions are guided by Supreme Court precedent as well as the Seventh Circuit.
And my last thing, I just note from 2006 to 2018, you served in the U.S. Attorney's Office, Southern District of Indiana, where you worked on cases from firearm offenses to financial fraud, tax evasion, drug trafficking. You also served as the office's national security chief, which is a major responsible position. How will that experience impact your approach?
I think it is important whenever you have taken an oath to ensure that you're executing that oath faithfully, more importantly, fairly and impartially. And someone who has worked on both sides of the aisle, both as a public defender and as a prosecutor, I truly appreciate the need when you're administering justice to do it in a way that your integrity as well as your independence is not questioned. That is what I have learned both as a public defender, a prosecutor, and now as a sitting judge that I will take with me if to be confirmed by this body.
Very good. Thank you, both of you.
Thank you.
Good luck.
Senator Cruz?
Thank you, Mr. Chairman. Congratulations to each of the nominees. Ms. Desai, you have been a Democratic donor. You have been a partisan advocate for causes with which you believe. That includes legalizing potent strains of marijuana, That includes fighting against religious liberty accommodations. That includes being active in fighting against school choice in the state of Arizona. Now, as an American, you have a right to express your First Amendment rights. The job of a judge is different. So I guess my first question is, how do you view the job of a federal appellate judge as different from being a partisan advocate?
Thank you, Senator, for that question. I think the role of an advocate is starkly different than the role of a judge. As an advocate, you start with a position. You represent, you're duty-bound to zealously advocate and represent your client and their interests. As a
Well,
judge,
but let me focus in particular, like you've been very active in an organization that fights against school choice in Arizona, and that has not been, as I understand it, as a paid attorney. That is a passion project of yours. You and I disagree on that. I think school choice is the most important civil rights issue in this country. I'm not interested in a substantive debate on school choice right now. My question to you is, if you are a federal appellate judge, Arizona is one of the leading states in the country for school choice, for providing low-income children, many of them minority children, the opportunity for access to an excellent education. If you're confirmed as a judge, will you be able to take your personal policy and political hostility to school choice, will you be able to set that aside and follow the law?
Senator, I am committed to following the law objectively and without interjection of any of my own personal or political views in any case that is presented before me if I am so fortunate to be confirmed.
And that includes on the topic of school choice.
Senator, no matter what matter I have in front of me and no matter what my personal or political views may be, they will not play a role in any case or decision that comes before me if I'm so fortunate to be confirmed.
Okay, let's talk about another area of your advocacy. In a legal challenge to Arizona House Bill 2023, which prohibited ballot harvesting, you argued the bill not only had the incidental effect of lowering minority turnout, but that it was actually, quote, designed to suppress voting in minority communities. As you know, the Supreme Court 6-3 rejected that argument. Do you still believe that prohibitions on ballot harvesting are designed to suppress minority votes?
Thank you, Senator. The Supreme Court in Brnovich v. DNC set forth the guideposts for determining when a law violates Section 2 of the VRA. They've indicated the factors to look at include opportunity to vote, openness of voting.
Okay, I recognize and I'm aware what the Supreme Court has held, and so it rejected the argument. I'm asking you, do you believe, you wrote as an advocate, that prohibitions on ballot harvesting are designed to suppress minority votes? Do you believe that as a factual statement?
Senator, the statements that you're reading from were written in an amicus brief as an advocate, filing that on behalf of my clients. As a judge, I would apply unreservedly, fully, and faithfully the precedent set forth by the Supreme Court.
So that brief you filed on behalf of a group called Fair Fight Action, is that correct?
Senator, I had two clients in that for that amicus brief. It was Fair Fight Action and the Arizona Voter Empowerment Task Force.
So has Fair Fight Action ever disputed the integrity of an election?
Senator, I'm not aware. I haven't studied that. I don't know.
You don't know?
I don't know.
But who started Fair Fight Action?
My general understanding is that Fair Fight Action is an organization that was started by Stacey Abrams.
And Fair Fight Action disputed and litigated against the integrity of the election in Georgia in 2018. You're right, it was started by Stacey Abrams. And in fact, Fair Fight Action argued in court that the voting machines in Georgia actually switched votes from her to Brian Kemp. Is that correct?
Senator, my involvement with Fair Fight Action extends to filing that amicus brief in the Brnovich v. DNC case about the Arizona election laws. I was not involved with and I'm not familiar with Stacey Abrams' gubernatorial campaign from 2018. I believe Fair Fight Action was actually created after that election, but again,
but it was created to challenge that election. It was part of Stacey Abrams' ongoing efforts to maintain that she was in fact the governor of Georgia, notwithstanding the voters of Georgia disagreeing and voting for another candidate. Let me ask you, the last major bipartisan examination of voter fraud was chaired by Democratic President Jimmy Carter and Republican Secretary of State James Baker. The Carter-Baker Commission concluded that prohibitions on ballot harvesting protect election integrity because ballot harvesting invites voter fraud. Do you believe Democrat former President Jimmy Carter was actively trying to suppress minority votes, as you argued the provision in Arizona was doing?
Senator, thank you for that question. I'm not familiar with the facts that you recounted, but what I can tell you is that I would faithfully apply the rule of law from the Supreme Court and the Ninth Circuit precedents if I'm confronted with a case that challenged election laws.
Final question, because my time's expired. You wrote that brief without examining what the Carter-Baker Commission recommended? You made that allegation about ballot harvesting without even knowing what the Carter-Baker Commission said?
Senator, again, as I sit here today, I'm not familiar with those facts, but like I said, I am committed to the rule of law and to implementing the Supreme Court's precedent with respect to how to evaluate state laws that are relating to ballot collection or any other laws that are challenged under Section 2 of the VRA.
Thank you.
Senator Tillis.
Thank you, Mr. Chair. Congratulations to both of you on your nominations. I watched your opening statements and much of your testimony from my office. And Judge Pryor, I was struck by how much your mother rides a roller coaster as you answer questions. She's going up and down, but she's obviously a very proud mother. I hope, and if I have time, I'll get back to you and ask you a question. Ms. Desai, you chose an area of the law that really requires you to wear a jersey, right? You're going to be if you're going to advocate for Democratic causes, you're going to have a blue jersey on. If you're advocating for Republican causes, you're going to have a red jersey on. So I'll leave it to the attorneys. I'm not one, but I'll leave it to the attorneys to ask the questions about the finer points of the cases that you've argued. But I am reminded of a district court nominee that we had in North Carolina who came before her, who had the red jersey on in election law. And I'm reminded of the fact that the questions that were asked from my colleagues on the other side of the aisle and the ultimate vote against his confirmation was driven purely by the clients you advocated for. I don't work that way. I do, like I said, I'll leave it to the lawyers to argue the reasoning behind some of the briefs that you've joined. But I want to ask more of a question because you clearly do have a liberal worldview. I'm not putting thoughts in your head, but if I can assume from the cases or the clients that you've represented that you have a liberal worldview. How do you, and you've clerked for the Ninth Circuit, but you do not have any judge experience. How do you make that leap? What life experience do you have that position you for serving on the Ninth Circuit? And how can I be sure that that worldview that you use to represent your clients as aggressively as you could will not influence the way that you decide cases on the bench?
Thank you, Senator, for that question. First, I want to note that I don't think it is true that some of my clients have been affiliated with Democratic causes, but I want to make sure that I note for the committee that I have represented clients, plaintiffs, defendants.
Give me some examples.
I've represented large corporations, Fortune 500 companies, small business owners. I've represented the government in many cases. And I have tried more than 70 cases to verdict and handled multiple dozens and dozens of appeals in matters ranging from business disputes, contract disputes, all the way to constitutional law issues. So my work as a litigator for almost 20 years spans a much broader range of clients and matters than just the ones, Senator, that you referenced.
I meant to say also that I think the only regret Senator Sinema has about her introducing you today is that it didn't happen yesterday on her birthday. She speaks very highly of you, and you've I think, advised her in her campaign. Is that correct?
Yes, Senator.
Judge Pryor, I was going to ask the same question that Senator Lee covered very well, but we have this ongoing debate about the plain text of the Constitution. I think you answered to a certain extent, but you have to apply it to modern challenges. We weren't contemplating the use of cell phones back in the day, but at the end of the day, is it a living document in that there are words in it that the Founding Fathers just didn't recognize, or do you ultimately have to go back to the plain text of the Constitution when you're finally deciding a case?
When deciding a case, it is important that all my decisions are guided by binding precedent of the Supreme Court as well as Seventh Circuit precedent, ensuring that I am guided by their decisions on what level of scrutiny to apply to a constitutional issue.
I just had one. Do you recall much of the facts related to Mitchum versus City of Indianapolis?
I do.
Can you tell me a little bit about why you ruled the way you did? And I think in the summary here, it had to do with the material facts that the defendant, I think in your opinion, presented several disputed material facts that he argues support a finding of the defendant's use of force in this case was unreasonable. Why was it unreasonable?
The court was unable to make that determination. As I outlined in that opinion, Mr. Tillis, it was important that the jury be given the opportunity to hear those facts. That's why it was denied on summary judgment, because the question was raised, or the argument was raised, regarding qualified immunity for those officers as to whether or not excessive force was used. The court could not answer that question based on the briefing and wanted to be able to present that case to the jury.
Okay, thank you. Thank you both. Congratulations again.
Thank you.
Thank you. Senator Blumenthal is recovering from COVID, and he was remote, but I think we have lost him. Is that correct? He's back on. Senator Blumenthal, can you hear us? Waiting for an apparition. Senator Blumenthal? Well, I'm sorry. I guess we don't have access to him, and I was going to give him his chance. But you had your chance and did well. Thank you very much, both Ms. Desai and Judge Pryor, for being here. And we were just discussing, Senator Klobuchar and myself, that you shouldn't hold it against young Johnny, that he invited you to a Constitution Day, which became a question at your confirmation hearing. No reflection whatsoever on him. Thank you very much. And I wish I had a few moments to sit and talk about people I know from Hope, Arkansas, including one who went to college with me. And Ms. Desai, thank you. What a wonderful family you have, and we're glad your mom could make it. I hope you feel real strong and better as the days go by. So the first panel is dismissed. Thank you very much. So if the second panel would please approach the table. And the senator from Minnesota would please come to order. Ask you to please stand and raise your right hand, not you, Senator Klobuchar. Do you swear or affirm the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? The record reflect that 3 nominees answered in the affirmative. And now you'll be instructed by me to correct my pronunciation of your name if I even got close to what it should be. And we'll first recognize Miss Maria del Antongiorgio Jordan. Is that close?
Close enough. Anton Giorgi.
Please proceed.
Thank you. Thank you, Chairman Durbin, and thank you for your kind introduction. I would like to thank you and Ranking Member Grassley for convening this hearing. I would also like to thank President Biden for the tremendous honor of my nomination. Being nominated to serve as district judge in the District of Puerto Rico is the highlight of my professional career, and for that I'm truly humbled. I am proud to introduce family members sitting behind me and acknowledge some watching remotely. My mother, Amelia, a trailblazer on her own right, here with me today. She instilled in me and my sister high moral values, the importance of education, and hard work. My cousin Xavier, who's representing the rest of my family who's watching remotely. Given the significance of this day, I would like to acknowledge my father, who's always in my heart. My father, an Army veteran, served for 35 years as a college professor at the University of Puerto Rico, and he instilled in me the love for sports. Because of sports, I entered college on a volleyball scholarship. It was through sports that I learned at an early age the importance of teamwork, discipline, and time management, skills that have served me well through my professional career, and that if fortunate enough to be confirmed, I hope will serve me well at the bench. I would also like to recognize my sister Michelle, my brother-in-law Sergio, my niece and my nephew, who are all watching remotely. My niece Marcela, a third-year student at Loyola University, dreaming of entering med school, and my nephew Mauricio, who having turned 16, his only priority is getting his driver's license, which he's doing today. To those who have consistently supported me and celebrated me happy times and have carried me through difficult times, thank you for inspiring me and encouraging me to become a better person and professional. Finally, I would like to thank the members of the committee for considering my nomination, and I look forward to answering your questions.
Thank you very much. And Judge Mendez Miro, close? Good.
Chairman Durbin, thank you for the kind introduction. I thank you and Ranking Member Grassley for convening this hearing. I am also grateful to the members of the Judiciary Committee for considering my nomination and to President Biden for nominating me to the District Court of Puerto Rico. I am honored and humbled to appear before you. Allow me to introduce those who are supporting me today. My father, Ivan, and my mother, Raquel. Through hard work and perseverance, they became successful professionals who sacrificed everything to provide us with an education and a better quality of life. My brother, Ivan Andres, a wonderful father and brother who lives in New Jersey with his wife, Erica, and their 3 children. Like me, he shares a passion for public service and is an attorney for the city of New York. My sister, Lisa, my forever confidant and a mother of 5. She's watching from Florida with her husband, Omar, expecting at any time the arrival of another grandchild. I would also like to acknowledge my grandmother, Puru, here in spirit, the daughter and widow of World War I and World War II veterans. Thanks to the federal government, she received multiple life-saving surgeries as a child that helped her live a long, fulfilling life. She cared for me while my parents worked, instilled in me her unwavering faith, and is, by far, the most significant reference in my life. I know she's proudly watching down on me today. I want to acknowledge my parents-in-law and my extended family for the love and support, and my friends, mentors, and colleagues who are watching this hearing from home. Lastly, I am here with my spouse, Maite Oronoz Rodriguez, the Chief Justice of the Supreme Court of Puerto Rico, my partner of 15 years. Her integrity encouraged me, inspired me, and gave me fortitude. We are the parents to 4-year-old twins, a boy and a girl, whom we hope can one day understand our passion for the law and justice, our commitment to public service, and our belief in a judicial system that safeguards the rights of all. Thank you, and I look forward to your questions.
Thank you very much, Judge. Judge Velez Rive?
Yes.
Close?
Perfect.
Oh,
Good morning. Thank you, Chairman Durbin, Ranking Member Grassley, and other members of the committee for convening this hearing today. I am deeply humbled and honored with my nomination and the privilege to be here. I have been a public servant for 24 years, the last 18 years as a magistrate judge. I take this obligation very seriously, and it has been an honor. If confirmed as a district judge, I will continue to fulfill my obligations to the highest standard with integrity and independence. I want to introduce the family members present with me today, whom I thank from the bottom of my heart for their unconditional love and support. My only daughter, who is the light of my eyes. She was a baby when I was appointed a magistrate judge. And as my judicial career has progressed and matured, she has become a loving and caring young woman. I am extremely proud of her, and I love her dearly. My identical twin sister, who is my rock, my best friend, and my soulmate. I thank her very much. My brother and 2 nephews who are present here as well for always encouraging me. My ex-husband and father of my daughter is also here, and he is demonstrating his support, and I appreciate that. I also would like to thank my parents, to whom I dedicate these milestones. My parents gave me unconditional love and instilled in me the moral values and faith that have guided me in life. I am here today because of the opportunities they gave me. My father passed away almost 4 years ago. Even though he's not here present physically, I always keep him in my heart, and I know he's here spiritually, proudly guiding me from above. My mother couldn't be here today, but she is watching from her home. I thank her for her love, guidance, and unconditional support. My sister-in-law, my niece, uncles, aunts, cousins, and many friends who are cheering from afar, thank you for your love and well wishes. Finally, I will also wish to express my heartfelt gratitude to my chamber staff, the court family, and so many federal practitioners for their enormous support. Mr. Chairman, thank you for considering my nomination.
thank you very much. It's my experience before this Judiciary Committee that lines of questioning usually relate to the personal experiences of the nominees. Some relate to principles of law. But I'd like to ask a question in a different area, which I found as a practicing attorney to be even more important: the temperament of the judge. You are seeking lifetime appointment to the federal bench. For some, that gives them an opportunity to finally be themselves. And for some, that gives them an opportunity to finally be themselves, and you can see it. It's not always a pretty scene in some of the courtrooms when judges feel that they are somehow lifetime arbiters of justice and have certain powers which go way beyond ordinary human interchange and conduct. So I'm going to ask you in the most general terms, if you have in your mind either a person or a model of a judge that you think really represents the best of the bench, that really is responsive to the parties involved and lets the average person feel that this courtroom is at least an honorable place where they can be respected during the process. Judge Velez Rive, would you start?
Yes, Senator. I believe that some of my mentors would be those that I would mention, and those would be Judge Consuelo Cerezo, Carmen Consuelo Cerezo from the district judge. She retired recently, and also Judge Gustavo Gelpi. They have, along with the other judges from the district court, they have showed me the duties and what you have to follow to be a good judge, that being open-minded, allow the parties to express their positions and evaluate those positions, and apply the rule of law to the facts, in particular in that case.
Thank you. Judge Mendez Miro.
Thank you, Senator. I have to immediately reference my mother-in-law, Judge Oronos Rodriguez. She was a court administrator in the same court that I served. She served there honorably for 16 years. She is the epitome of a hardworking judge, always impartial, always true to the facts, always with strict adherence to the law, but also she balanced her family life. She has a wonderful marriage of 59 years and 4 kids and a ton of grandchildren. So not only was she amazing in court and she had great temperament, but she also is a great woman of faith and a great example for me to follow.
Thank you. Ms. Anton Giorgio?
Thank you, Senator. I always admire, as Judge Velez Rivas said, Judge Carmen Cerezo. Judge Cerezo was the first Hispanic female appointed to the federal bench. She served in the District of Puerto Rico for almost 30 years. She just retired. Judge Cerezo had an impeccable command of the rule of law and an impeccable command of the rules of evidence. She was soft-spoken but firm, very collegial with the attorneys, with the parties, and with her staff. And it's somebody that has inspired me. And if I was fortunate enough to be confirmed, those traits are the traits that I want to apply if I become a judge.
Thank you. Senator Kennedy?
Thank you, Mr. Chairman. Judge, Counselor, congratulations. Counselor, what is subject matter jurisdiction?
Senator, subject matter jurisdiction refers to the ability of the courts to entertain matters, cases that has to be presented in federal court can be moot, have to be ripe, parties have to be standing, and of course, federal courts can only see cases and controversies.
What is substantive due process?
Substantive due process is the process that is used when deciding the constitutionality of a statute, of a matter. Distinct from procedural due process, which is based on the process that the courts follow when people are deprived of the due process of law, property.
I'm sorry. What's the difference between substantive due process and procedural due process?
It's the approach.
And how is the approach different?
It's different because the procedural due process refers to the procedure that it's followed, while the substantive due process technically refers to the way the constitutionality of a statute it's viewed. That's my understanding.
Judge, the middle judge, I'll call you. Can the United States Congress do anything, legislate in any area that the Constitution doesn't prohibit?
Thank you for your question, Senator.
You're welcome.
That would be correct. I believe it's under the 10th Amendment. There are certain discretion for Congress to go beyond the list that the Constitution provides in terms of the matters that can be legislated.
So you believe that Congress has plenary power as opposed to enumerated powers?
Well, I think that the Supreme Court has acknowledged that there are some rights and that are not enumerated, and the Constitution recognizes the Congress's ability to,
No, we're not talking about unenumerated rights. I'm talking about the power of Congress to legislate.
Congress indeed has that power as per constitutional acknowledgement, sir.
Okay. So you're telling me that Congress can legislate in any area unless someone can point to the Constitution that says it cannot?
My understanding would be that Congress indeed can legislate extensively. It doesn't have to be enumerated exclusively. I think that's a recognition that Constitution acknowledges.
I don't think that's right, Counselor or Judge. Judge?
Yes.
Can you tell me what the Chevron doctrine is?
Yes, the Chevron doctrine is a Supreme Court case in which the Supreme Court ruled that administrative agencies should be given deference for the decisions that they make. And that decision was questioned somehow in the recent EPA Supreme Court case.
Okay, that's right. What's the holding in Obergefell, Judge?
For me?
I'm sorry.
Oh.
I'm sorry.
I'm
Start
sorry.
here and go back that way.
Okay.
Obergefell is the Supreme Court case that recognized same-sex marriage.
Did it hold that same-sex marriage is legal?
Well, it held that it is a protected constitutional right.
Yeah. See, that's not the way I read Obergefell. What I read Obergefell to say is that so long as the relationship is not incestuous, that you and I have the right to marry whoever we want to. And there's no reason to exclude people of the same sex. That's very different, is it not?
Well, Senator, I granted you what I believe that's the holding for that case. However, if I were to become a district judge and if I were to apply that case, I assure you that I will apply the holding of that case faithfully.
All right. Counselor, let me jump down here. Can you tell me what, if you're on the federal district bench, you'll be asked on occasion to issue a universal injunction. Can you help me understand the legal basis, the authority of a federal district judge to issue a legal injunction or universal injunction?
Senator, let me start by saying that I have never worked with a universal injunction, nor the District of Puerto Rico has ever issued a universal injunction.
Yes, ma'am.
Having said that, there is a lot of debate as to
Yes, ma'am, but the
what's the
chairman's going
source?
to cut me off. Just tell me what the legal authority is for a federal district court judge to issue an injunction that affects beyond his or her judicial district.
As I said, I have never worked with a universal injunction. My understanding is that it comes from Rule 65 of the Rules of Civil Procedure, which are the rule that governs injunctions. That's my light understanding on the matter. As I've said, I have never worked with a universal injunction.
Okay. Thanks, Mr. Chairman.
Thank you, Senator. Senator Blumenthal is once again attempting to join us remotely. As I said, he's recuperating. We're trying to give some deference, and Senator Klobuchar has been nice enough to hand it off to him if he's ready.
I am ready.
Ask him how he's feeling, Mr. Chairman.
I've been instructed to ask you how you feel.
I'm feeling much better. I'm ready to return to the Senate anytime I can test positive. So, but really appreciate this opportunity to participate, and thanks to Senator Klobuchar for deferring, and thanks to every one of the nominees. I know all of you by reputation. I know Judge Mendez, Mendez Miro by personally, and I'm deeply impressed by all of you and by the strong expressions of support that you've received from the Puerto Rican bar and your colleagues on the bench. And I just want to make a very simple point. Number one, these judicial positions should have been filled long ago. I'm glad that we are moving to fill them now, and I hope that we will do it expeditiously. These nominees have not only won respect from their colleagues and from many of us, but I think from the people of Puerto Rico, they also will command respect. And each of you has compiled a distinguished record, either on the bench or in your private practice. I'd like to ask each of you, perhaps beginning with Judge Mendez Miro, and then Judge Mendez Riva, what is the experience that you have on the bench and then in private practice as well that you think prepares you for serving on the district court for Puerto Rico?
Thank you for your question, Senator. I've been a sitting judge now for close to 6 years, and in those 6 years, I've been able to pen over 750 opinions. I've also joined thousands of opinions on a wide range of issues. What I do on a day-to-day basis is solve cases and controversy, apply the law to the facts. That's what I do for breakfast, for lunch, and for dinner. So that adjudicative experience and my record as an impartial, meticulous, respectful of the law adjudicator, I think would serve me very well, coupled with close to 20 years of experience, and not only in the private sector, representing corporations and employers, but also working in the 3 branches of government. It gives me a full sense of what are the lanes where a judge needs to be walking, and other branches as well. It's a very diverse background. It's very enriched. I've been able to litigate on behalf of the 3 branches of governments. Civil, I solve half of my docket, probably 45% of my docket is criminal in nature. Actually, the docket, it's a court of general jurisdiction, my court. The docket is actually over close to half longer than, or I should say, it's double the docket of the PRDC, where I was so fortunate to be confirmed. So I think that also working in a collegiate court, where you have to debate and delve into new and challenging issues of the law, would certainly serve me well as well. Thank you.
Thank you. Judge Velez Rive.
Thank you, Senator. I have been a magistrate judge for 18 years, and as a magistrate judge in Puerto Rico, which is a court which has a huge and congested docket, I've had a chance to entertain thousands of civil and criminal matters. I have written over 3,000 reports and recommendations, hundreds of opinions. I have managed cases for the district judges, for discovery issues, for settlement conferences, mediations. I have covered hundreds of duty weeks in which we receive many defendants, and I have held all the preliminary hearings that are called for the duty weeks in Puerto Rico. Those include arraignments, preliminary hearings, detention hearings, bail hearings. I have also managed many civil matters upon referral of the district judges. For example, for a motion for summary judgment, motions to dismiss. So in essence, I have done everything a district judge does, but a few things, such as not presiding in a criminal felony case and sentencing a defendant. But I have that experience, which I think will serve me well, and I will hopefully, if I am confirmed, hit the ground running.
Councilor Andrew Giorgio.
Thank you, Senator. Thank you, Senator. I started my legal practice in 1995 in the biggest law firm in San Juan, Macono Valdez. And I spent 23 years at that firm. During my time at the firm, I enjoyed a long litigation career in civil complex matters, in which I was the lead attorney in thousands of cases and in 42 trials. I ended up my career at McConnell Valdez with 91% success rate in trials. I was also, and have been also, a member of every single court committee. I've been in charge of the court's overall governance and administration, and I have worked closely with the judges. Some of the committees that I have participated with or in are for example, the Local Rules Committee, in which we revise the local rules of the court. The CJA committee works with the CJA panel of attorneys, the jury committee, which we're just working on the jury model plan. So I believe that with the administrative experience and the know-how of how the court works, plus the extensive litigation experience that I possess, I'll be able to make a contribution to the court if fortunate enough to be confirmed.
I thank you all. I apologize, Mr. Chairman, for going over my time, but I thought it important to get those qualifications on the record. And I thank each of the nominees and, very importantly, your families, all of your families, for your service. The people of Puerto Rico deserve federal justice, just like all of our fellow Americans, and I hope these positions will be filled promptly. Thank you very much.
Thank you, Senator Blumenthal. Get well. Come back soon. Senator Puerto.
Thank you very much, Senator Durbin. I guess I'll start with you there in the middle, Judge Mendez Miro. While serving as Director of the Judicial Programs for the Puerto Rico Judicial Branch, you led the development of numerous projects and programs, as noted, including adult and juvenile drug courts. I've long been an advocate for drug courts from my 8 years as prosecutor. My dad struggled with alcoholism, spent his last about 20 years sober. As he said once in the assisted living, it's hard to get a drink around here anyway, but he did well the last few decades. And so I've just had a lifelong interest in this, and we've done work in finally getting some federal drug courts up and going, and also funding for state drug courts. Could you talk about your work on diverting nonviolent drug offenders to treatment rather than incarceration, rehabilitation? Senator Durbin here, of course, worked on the First Step Act and some of the other things that we have done here, the crack cocaine disparity, many things going on in Congress. But I want to just get your frontline experience here and what you think should be done.
Thank you so much, Senator. The right to rehabilitate is a constitutional right in Puerto Rico. So it's of paramount importance in Puerto Rico. That's probably one of my most gratifying experiences in policy making, trying to deal with prosecutors and court staff and judges to design guidelines that are balanced, that are addressing the issues of addiction in a way that understands that it's a sickness. I too come from a family where alcoholism has been a major and significant part, and that has also allowed me in the process of developing these programs. We were fortunate enough, former Chief Justice Hernandez Denton was adamant that we needed to create the first juvenile drug court in Puerto Rico, and we did during my tenure. It's not only through the judicial process, but just being able to play basketball with the participants and seeing that role of a judge where you are from the bench basically changing somebody's life. And that doesn't mean that the person is not gonna finish his sentence or her sentence, but it just means that you use that robe and you use the bench for something better, to reinsert someone to society. So that was probably one of the most rewarding experiences professional in my life. Thank you for your question.
Well, very good. And I want to note, just for the record, or in addition to your years of experience, impressive credentials, I think it's also important to note that if you're confirmed, you will be the first openly LGBTQ federal district judge in Puerto Rico. So firsts are important, says the first woman senator from Minnesota. So, all right, next up, we've got, I thought I would ask you, Judge Velez about your work as a prosecutor, actually, since you have, it's been noted, since 2004, you served as a magistrate judge for the U.S. District Court for the District of Puerto Rico. And by the way, I put a number of, as I noted in the previous panels, magistrates in our federal district court. They've been recommended through my committee. During that time, you presided over 26 civil and criminal trials that went to verdict or judgment. And then from 98 to 04, you served as an assistant U.S. attorney, where you drafted over 80 appellate briefs and argued multiple cases before the U.S. Court of Appeals for the First Circuit. How will that experience as a federal prosecutor inform your approach to working as a district court judge?
Thank you, Senator, for the question. Yes, I was an assistant United States attorney for 6 years. I spent half of the time doing criminal appellate briefs and then the other half doing civil litigations representing the government. That gave me a balanced background, both in civil and criminal law, to become a magistrate judge. So it helped me as a background for becoming a magistrate judge, and that gave me knowledge on the law. I did not have the privilege of litigating criminal cases at the district court level. I just did appeals, but the appeal work and the civil litigation allowed me to be prepared to become a magistrate judge. And certainly the 18 years that I have been a magistrate judge have given me a very experienced background to become a district judge if I am so fortunate.
Thank you very much. And with you, Ms. Anton Georgi, thank you for being here, your nomination. It's my view, given the challenges that we're facing with the judiciary and the trust issues, some of it coming out of some of the recent Supreme Court cases, ethics issues at the Supreme Court and other things. Can you share your perspective on the importance of the independence of the judiciary?
Absolutely. Absolutely, Senator. Thank you for the question. I believe that the independence of the judiciary is of utmost importance for our democracy. It's a check and balance issue. An independent judiciary in which judges can render their decisions strictly based on the law and on applicable precedent, and not on outside factors or pressures, I think only enhances the credibility in the judicial system and the trust in the judicial system. Much has been said about jurors being the protector of liberty. I have to say that independent judiciary, it's the protector of the rule of law.
Exactly. Okay, good way to end. Thank you to all three of you. Look forward to helping you as you move to the floor. So thank you.
Thanks, Senator Klobuchar, and thanks for deferring to Senator Blumenthal. It was nice of you to do that. Thanks to this panel. Two things I would say to you. First is you were probably warned in advance of Senator Kennedy's bar exam, which he administers regularly. Fortunately, he does not ask members of the Judiciary Committee to try to answer the same questions. Secondly, you have a possibility that people will send written questions your way. They have a few days to complete those and send them to the committee. So if you will pay attention if they head your way to return them as quickly as possible, we'd appreciate it. Thank you, your family and friends for joining us this morning and this afternoon, and we look forward to moving your nominations quickly. Thank you. Committee stands adjourned.